So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
If I may, Madam President,
Merci beaucoup,
of course,
Thank you very much.
an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16, of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out